उन खां पोइ असांजो जेको सेकंड चैप्टर आहे उहो मीनिंग ऑफ जेको आहे मीनिंग एंड काइंड्स ऑफ लॉ चैप्टर द मीनिंग एंड नेचर ऑफ लॉ आर प्रॉपरली एक्सप्लेन बाय थ्योरीज dealing with the concept of law. Nevertheless, it is useful to briefly describe how the meaning of law is understood through the definitions. The meaning of law. In this section, we will first look at law as a social institution and then try to define it in simple terms. Difficulty of defining the term law. Law is a complex social institution. For centuries, legal philosophers have struggled with the problems of understanding the law, as law has varied in different societies and at different stages of historical development. It has become difficult to develop definitions of law that is universally acceptable. The proof of this is the number of theories that continue to wrestle with the basic question, what is law? We look at the theories later. Some scholars have suggested that defining law serves no purpose. Instead, they suggest a total involvement with the law will provide the individual with a feel for the law. This approach does not help the student. However, a student who is just starting a serious study of law. Law is a social institution. Law says theirs is a social institution. He then proceeds to provide a broad basis for the law. The reasons why he does this is because the approach of socialists have been found to be the easiest to understand. Sociologists view society as a vast social system that is structured and molded by interaction among the members of society, and this interaction they feel the need to determine what's proper or the right conduct and what is wrong. Further, they wish to regulate this conduct so that friction is reduced in their dealing with each other. The position of each member in a society is identified by two things: the member's role. This is identified through the obligation that he has to meet. The member of status. This is identified through the set of rights that the member enjoys. These obligations and rights that determine the role and the status of members of society are expressed in the form of rules known as the norms. All the norms in a society are not clearly stated. For example, norms that define the role and status of parents are generally understood without being stated in the form of rules. Everyone knows that a father has to be in charge of his household, provide for the family members of the family, and take a decision about the well-being of the family. It's generally felt that there is no need to state such rules very clearly to write them down as a statute. As compared to these, there may be other rules. For example, rules governing the marriage and divorce that have been made more explicit over time and have been turned into laws or statutes. These rules define the rights and obligations of a person. In simple society, there was little need to spell out all the rules of explicitly. But in complex society, this need is immense. Consequently, an effort has been made to clarify and reward rules so that all people may come to know their definition, limits, and application. Some of these rules became law, receiving expansion through the growth of courts and legislative bodies. The rules of law in society are legal or formalized norms that define how people of institution are to act and what state officials are supposed to do when rule is violated. Every law expresses a valuation. There is a value choice. One is to decide which option is chosen. It is for this reason that law is based on the value system that represented our social consensus. Some rules, however, are directed to everyone, like the rules for murder, while others are directed to particular group of people, like the rules of traffic are directed towards drivers. And definitions of law. Collectively, the rules of law are laws serve the means of social control in society. Law is therefore defined as a formal means of social control that involve the use of rules that are interpreted and are enforceable by the courts of a political community. In other words, law is that part of normative system that is sustained by state power. This definition is quite similar to the one given by Salman. The law is the body of principle recognized and applied by the state in the administration of justice. Or more shortly, the law consists of the rules recognized and acted on in courts of justice. These are the definitions of laws. And the difficulty in Salman definition is then one is to explore the meaning of justice, to understand the meaning of law. Further recognition by courts had been changed to interpreted and enforced. In the first definition, this pertains to the question whether law becomes law only when it is recognized as in the unwritten common law by courts or whether acts of a legislature enough. Law is a formal ordering process as compared to other means of social control. Law is not the only means of social control. There are many other institutions that help give order to social life. They are said that law, morality, religion, fashion and opinions are moods of social control, and that they are prescribed in various ways how people are to behave. What does the law from these other social ordering institutions in the formal and general nature of its ordering process? By this we mean that when the informal method of other institutions fail, dispute will be brought before a court of law, where the issues will be clearly defined by highly structured, often consuming court proceeding. Law then is a special kind of formal ordering process that is characterized by the carefully chosen steps it follows in an effort to create, maintain or restore the social order. This elaborated decision-making process what distinguishes law from other means of social control. Kinds of law. There are the two kinds. We have said law is a formal means of social control. Then involve the use of rules that is characterized by carefully chosen steps and through which it achieves its purpose to facilitate the use of rules and orderings of society. Law has been classified into various divisions. Divisions are as follows: of substantive and procedural law. Substantive law has been defined as the body of law that creates, discovers, and defines the rights and obligations of each person in society. Substantive law tells us what the law is, what rights we are paid to have, and the duties we are told we must accept. The Pakistan Penal Code and the contract are example of substantive law. When a crime is committed or dispute arises, the procedural law is activated and the courts follow the steps laid down in the procedural law. The criminal procedure code and the civil procedure are example of procedural law. Civil law and criminal law. Criminal law deals with the crimes and offences, whereas civil law deals with the dispute between parties regarding contract, inheritance, and private injuries. In general, civil and criminal law have similar function as an institution of social control, but have three basic differences. Criminal law deals with the crimes that are public wrongs involving a social harm, and civil law deals with the private wrongs and injuries to an individual, more commonly references to a tort. In civil proceeding, the redress provide injury known as remedy and may simply be money payable to the injured party known as damages. Court are prohibiting ordering the certain action in criminal proceeding. Our redress may be a fine payable to the state, a prison sentence, stripes, combinations of these, stoning to death, last two being an Islamic form of punishment. In criminal cases, the government or state is the litigating party, whereas in civil cases, the government is only present as a judge, the injured party being the litigating party or the plaintiff. Statutory law and case law. This division was originally called the division between statutory law and common law. In Pakistan, the common law is codified in the form of statutory law, but for elaboration for the meaning, recourse may still be had to common law concept. The common law was bound in case law, is based on the doctrines of precedent or statute in the USA. The term common law may be sometimes means anything not covered by statute. This the term common law marriage, where a man and woman start living together without a formal contract of a marriage.